Give me a second. This is probably on my own computer. I don't know why it won't allow me to do this. It won't allow me to duplicate.
Plug back in. Where's my go-to?
Do that. I can't remove it to that.
Hi, everybody.
Every second screen only. Does that work? Hello, folks at home. Can you hear me now?
Yes.
Okay, I'm having some technical troubles in the room, so if you just give me a minute. For some reason, the projector is not going. So. Oh. You know what the problem in the room is? Moron forgot to plug in the HDMI cable.
Professor, don't be so hard on yourself.
Well, the senior moment.
Did we figure out with the people with the comms if it's earlier or later, or you want to email me separately?
Just give me a second.
All right.
On that point, Professor, you start having senior moments.
All right, so for whatever reason, I'm not going to be able to get the in-class projector working, so everyone's going to have to follow me. I apologize. Everyone in class will have to follow me, and luckily it looks like everyone has a laptop, so everyone will have to follow me on the PowerPoint, and that should be up right now. Okay, let's talk for a couple of minutes. Let's do this. What I'd like to do is, this is these are the slides from class 16. Class 16 involves the dormant commerce clause, and then finishes up with privileges and immunities under Article 4, okay? That is the last topic that we're gonna have to study for the bar exam. I mean, for the bar exam, for the exam before Thanksgiving. Everything through class 16, according to the PowerPoint slides, not according to what the syllabus says, because I don't always follow the syllabus. Sometimes we fall behind, and then later we catch up. We're in very good shape to finish this stuff up. So and I will send out an email on this once again. So it'll be everything we have done through the privileges and immunities clause of Article 4, okay? Which is the last subject under class 16. Let's talk about the, let me shut this down. let's talk about the remaining classes for a second. And then we'll talk about the exam on Tuesday, the 24th, and then the final exam on, I think that's also a Tuesday, December 22nd, okay? This is our last live class today. We are not going to do a class on Tuesday, okay? I'm going to tape a class on Tuesday, make it available for you guys to watch at any time when you're done with your final exams. So the reason I'm not doing a class on Tuesday is because you guys have, some of you have as many as 4 exams and you don't have a reading week. So, you know, if you start to take this weekend coming up to study for the final exams, and then you don't have to come to classes on Tuesday either. And I'm told Professor Sullivan, Dean Sullivan is not doing class on Tuesday as well for UCC. And I believe that Professor Kapani might be leading in that direction for evidence as well. I don't know what Professor Rodriguez is doing. I haven't talked to him for probably a good week. You know, that will give you sort of a semi-reading week for next week. And then obviously a week from Tuesday is my exam. I think you start your exams on what, Thursday and Friday? What do you have them on? Friday, Monday, Tuesday? Thursday, Friday, Monday, Tuesday, something like that?
Which
Okay.
ones? Which, what are you talking, this coming week? I mean,
They start on the 18th.
Yeah, the most that any
20,
of you will have are 4 exams. The 4 exams would be criminal law, UCC, evidence, and con law. Okay.
right?
So, so as I say, I will take class 25. I will have it posted. And then when you're done with your exams, and you should be done with your exams by the 23rd, is that the 20, I'm sorry, whatever that Wednesday is before Thanksgiving, you'll be done with your final exams. I think mine is the
25th,
last
yeah.
on Tuesday, okay? Then anytime after that, you can take a look at class 25, okay? Now, the week after Thanksgiving, I believe we have class on Tuesday the 1st and Thursday the 3rd. And Thursday the 3rd is our last class. Both of those will be remote. I'll run them at regular class time. So the day class will have a 12:30 class. The evening class will have a 9 p.m. Class. So I'll run those at the regular time, but everyone will be remote. And including me, the likelihood of me coming into the building to tape that class is going to be very low. I'll probably just do it from home, okay? And then obviously we'll have our final exam. Now, I mentioned this in the last class, I'll mention it again. The exam on Tuesday, the 25th, whatever the date is, the one before Thanksgiving, will be, you'll download it from Twen and then upload your answers on to Twen. A couple of you may have accommodations that require a different method. I'll communicate with you privately in that regard, okay? The exam starts at either 4 o'clock or 6 o'clock. A week from Tuesday, the exam is at either 4 o'clock or 6 o'clock. I don't care which one you take. Since everyone's going to be taking remote, you can take it either at 4 or you can take it at 6, okay? If you take it at, there'll be a little bit of overlap. So there's going to be there's probably going to be 4 Zoom rooms set up. One for standard time takers at 4, one for standard time takers at 6. And then one for people who get time and a half, and then one for people who get double time, okay? Now, I haven't decided what to do with the time and a half and double time takers yet. If I had my druthers, I would have you all start at 4 o'clock when the day class starts. And then the people who get double time would be ending obviously at 8 p.m., okay? If any of you cannot start at 4 p.m., could you please send me an email and let me know? So if you're a double time taker or a time and a half taker and you cannot start at 4 p.m., send me an email and we'll make other accommodations for you to start later. I understand that some people have classes. I'm sorry, some people work in the evenings especially, and might not be able to start an exam at 4 o'clock. We'll deal with that. I'll accommodate that, obviously. Okay. So that's where we're going at this point. Okay. We're in pretty good shape. So today is class 24. I will tape class 25, and then the week after Thanksgiving, we'll do class 26 and 27. I will either finish equal protection today or come close to finishing equal protection today. We will start with fundamental rights and essentially have 3 classes to do fundamental rights. And that's a pretty good amount of time to do fundamental rights. Okay. So let's get going again with equal protection. Now, when I can catch my breath finally, sometime over the weekend, I will send you all up an email blast, obviously notifying you of you know how the exam is going to run in writing, so that you will all have it. Okay. Okay. We had done rational basis. We've reintroduced ourselves to the 3 standards of review: strict scrutiny, intermediate scrutiny, rational basis. We did rational basis. We saw rational basis was fairly straightforward, you know, any conceivable justification, except in 2 circumstances. Circumstance number 1 was disability, the Cleburne versus Cleburne Living Center case. They used rational basis in name, but they seem to be inching towards intermediate scrutiny in de facto. Okay. We call this rational basis with bite. And the same thing happened in regard to sexual orientation in Romer versus Evans. In name, Justice Kennedy was saying that strict scrutiny applied. I'm sorry, that rational basis applied to sexual orientation, didn't want to make it enhanced scrutiny, but then sort of considered it under enhanced scrutiny. The thing that those 2 situations have in common is a certain mean-spiritedness of the governmental actions. A mean-spiritedness that suggested that the only reason the actions were taken, you know, it was to prevent a group home for intellectually disabled adults in the Cleburne case. And in the Romer versus Evans case, it was to punish the LBGT community through this referendum that was passed, referendum 2 that was passed in Colorado. Okay. So whenever you see that sort of pettiness, mean-spiritedness in the laws in those areas, even though you may be using rational basis, the courts are going to be less deferential. Essentially, they're saying that if it's clear that the only purpose is discrimination, then it fails even under rational basis. So now here we are at strict scrutiny, race, national origin, and alienage. And when I say alienage sometimes, okay? The general rule is that alienage is strict scrutiny, but we're going to talk about a big exception to the rule that they're going to test you on in the bar exam, where the standard of review will be rational basis, okay? We're also going to see this little quirk when it comes to race, the sort of 2 quirks when it comes to race. Remember that the 14th Amendment Equal Protection Clause was enacted because of race, okay? Race because an entire race of people in the United States had been enslaved, essentially, or nearly an entire race of people had been enslaved, and the 13th Amendment abolished slavery. And Congress understood that a lot of the so-called badges and incidents of slavery would still remain. People were prejudiced, and the prejudices would continue. And this is why the 14th and 15th Amendments were passed to deal with those. But there's going to be one circumstance where race is considered under rational basis instead of under strict scrutiny, okay? It's the Washington versus Davis exception to this. I'm going to make a big deal out of it because it's going to be on my exam and probably a quarter of you are going to get it wrong. It happens every single year, okay? So my joke that I always say is I'm not like the other professors. They just screw you, okay? What I do is I tell you how I'm going to screw you and then I screw you. But at least I'm giving you the warning of what's coming when we get to Washington versus Davis, okay? And then you'll have no one to blame but yourself if you miss it.
I wonder if that's better or worse.
It's better. Information is better than none in all cases. Strict scrutiny. We know the test. First of all, we know it applies to these groups that, number one, tend to have immutable characteristics. Characteristics you're born with and cannot change. So whether you're black or white or Asian or Native American is something that you can't control. You're born with your race, okay? The same with national origin. You're born in a particular country. You can't help it. That fact is not going to change. And if you're in the United States, the fact that you are a citizen of another country, at least when you entered the United States, is another immutable characteristic. The other time we use strict scrutiny is when there has been a history and tradition of discrimination. So, you know, America's original sin is race, slavery, and racial discrimination. That is sort of the referred to as the original sin, what we've had from the beginning and continue to struggle with until this very day, okay? So that's obviously got rich is not a good word, but a long, troubling history of discrimination in regard to race. The same is true for national origin, and the same is true with alienage. What we will see when we do gender, we don't have to spend a lot of time on gender discrimination or sex discrimination, is that we came to realize that there's also this immutable characteristic called gender. You're born with your gender, okay? That's something that you can't change. Is that you were born with it. You can change your gender, but you can't change the fact that you were born that way. And there's a long tradition of discrimination against women in this country as well. So, you know, as a result, this second category, the second enhanced scrutiny was created, intermediate scrutiny, okay? And I think it was created because they just didn't want to lump sex discrimination in with strict scrutiny. Back in the 1970s, when this was done, the court was leaned towards the conservative side and didn't want to expand strict scrutiny all that much more. Okay, I wanted to leave it just race, national origin, and alienage. Now, an interesting question arises today with sexual orientation. Some people believe that sexual orientation is not an immutable characteristic. You're not born with it. For whatever reason, you make a choice as to your sexual orientation. Other people dispute that and say that it is an immutable characteristic. There also seems to be an argument as to how much there's a tradition and history of discrimination against the LBGT community. Go ahead, Teddy.
I'm just curious about the other thing. Is there more than one gender?
Sure. Yeah, absolutely.
And that's brought up in the cases?
It's about to, because the Supreme Court just decided that the Civil Rights Act of 1964, which banned discrimination on the basis of sex, did apply to same-sex couples. Okay, they just decided this past June. Does apply to same-sex couples. So they take the word sex, construe it to apply to same-sex couples. So you know there's going to be situations of people who have had gender transfer surgery coming up as well, and the court hasn't ruled on that yet. So we're going to have to see what, you know, where the court is going to be going in that regard. Okay, that'll be interesting to watch. Okay, Teddy's question, for those of you who might not have heard it at home, was there's more than two sexes now, obviously. So, you know, does this apply to all those? And, you know, the answer that I just gave him was, we don't know yet, because we haven't had enough cases to deal with that at this point, okay? So look, focus in on learning these tests. Know that strict scrutiny, the burden of proof is on the government. They have to show a compelling governmental interest, and they have to use the least restrictive means of achieving the goal. It can't be over-inclusive, okay? And it can't be under-inclusive either, okay? That's how they test you on multiple choice questions on the bar exam. They test you on the tests. Know that intermediate scrutiny, the government bears the burden of proof still. But this time they don't have to show a compelling interest. They instead have to show an important interest. And they don't have to show fully that the government used the least restrictive means, but they have to show a substantial relationship between the goal achieved, that sought to be achieved, and the means that are used to achieve it. And then know that with rational basis, the government does not have the burden of proof. The plaintiff does. The plaintiff who's challenging the law does. And the plaintiff has to prove the non-existence of a conceivable rational justification. Here, under inclusiveness is allowed. You know, we did the Railway Express versus New York City case to show that you don't have to solve the whole problem or even come close to solving the whole problem. And over-inclusiveness is allowed. We did the Beezer case, where New York seemed to have a very strict anti-methadone law that would have not only taken, you know, users of controlled substance, you know, out of the employment realm, also those who had already kicked the habit and were not using at the time. That was way over inclusive, but the court said that's okay under rational basis, okay? So here we're going to look at some of the things that come up under strict scrutiny. And the first thing we're going to look at, obviously, is race. And we're going to start with the Dred Scott versus Sandford case. This here is Dred Scott. This case is in your book for two reasons. Number one, I think it's just to shock you and piss you off, because when you read the decision of the case, it's pretty outrageous, okay? And number two, it shows you why the 14th Amendment ended up dealing with citizenship at the very beginning of the 14th Amendment, saying who's going to be a citizen. It was specifically because of the Dred Scott case that first provision was put in, okay? So Dred Scott was a slave. He was born in Missouri. The phrase they used was his master was a citizen of Missouri. He went with his master to Illinois for about 10 years, from 1833 to 1843. And Illinois is a free state, not a slave state, okay? He also lived in the Louisiana Territory. You guys are probably thinking that the Louisiana Territory is a slave state area. And indeed, Louisiana has always been a slave state area. What you don't know is that the Louisiana Territory, when we purchased it, when Thomas Jefferson purchased the Louisiana Territory, it extended way, way, way up into the north, up to the Great Lakes. So states that would become free states were in the Louisiana Territory at the time, okay? And there, slavery had been forbidden by this constitutional act, the Missouri Compromise of 1820. Obviously, when Scott returned with his master to Missouri, he was, while he was walking around in Illinois and the Louisiana Territory pretty freely because there's no slavery in those states, when he returned to Missouri, he returned to all the burdens of slavery that applied in Missouri. And he filed a lawsuit in a Missouri court seeking his freedom, claiming that because he lived in free territory, this made him a free man. And here's the part that's going to piss you off about the court. This was written by Chief Justice Taney. It's pronounced Taney, but it is spelled T-A-N-E-Y, Chief Justice Taney. This is widely considered to be one of the worst, if not the worst, opinion of the Supreme Court in the history of the Supreme Court. Okay, and essentially, you see all the insults that are there. Essentially, what they said in this decision was that Dred Scott was not a citizen who was deserving of protection under the Constitution. And he was not a citizen because he was a member of an inferior race that had been subjected by a superior race. And so that's that's why I say that if this case doesn't piss you off, not many are going to when you read it. And you know that after this was read, you know that if the 14th Amendment had been ratified, and it did not deal with the question of slavery, what would a prejudiced or biased Supreme Court do in regard to applying the 14th Amendment to former slaves? It would say it doesn't apply to them, they're not citizens, okay? So therefore, the first sentence of the 14th Amendment, all persons born or naturalized in the United States are subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. So in other words, take away any and all claim that former slaves are not citizens. Got right down to business in doing that. Why? The slave trade actually, let me rephrase that. The international slave trade died decades before the Civil War. We stopped importing slaves from the African continent long before the Civil War. Virtually every slave that was in the country at the time of the Civil War had been born in the country. Quite frankly, was probably a second or a third or a fourth generation slave who had been born in the United States. So Congress, when they wrote the 14th Amendment, recognized immediately that this first sentence would take away any argument that the slaves were not citizens and that they were therefore subject to the protection of the 14th Amendment, okay? Korematsu versus the United States. This is a case that is not based on national origin. Well, it's based on national origin and it's based on race, but is not based on alienage. Fred Korematsu, the plaintiff in this case, was born in the United States. He was a United States citizen from birth. On December 7th, 1941, the Empire of Japan obviously invaded the United States. Hawaii then was United States territory, not a state. At that point, they did an aerial attack of the island, destroyed a large part of our fleet. Mayhem broke out on the west coast of the United States. So if you think about Hawaii being halfway between Asia and the United States, the thought was that the Japanese Empire was not going to stop at Hawaii. It would eventually do a land invasion on the west coast of the United States. It would bring ships over and do a land invasion, okay? And the west coast broke up and sort of fell into a state of paranoia. People started doing civil air patrols, flying up and down the coast. They put up watchtowers on the coast, so people would go up with binoculars and look for Japanese ships coming and the like. They started having blackouts at night on the West Coast. You guys understand that early on in World War II, radar was not sophisticated enough to put on airplanes to be able to find targets. So the airplanes would usually have to do sight bombings. And this was, much more important in Europe than it was on the West Coast. But the reason why people have blackout blinds on windows to shut out all light was because during night bombings, the bombers would look for lights to determine that they had reached their destination, okay? West Coast is in a panic. And, all presidents have good and bad. And, a lot of people think that FDR was one of the greatest presidents in American history. People are complex, and FDR did issue this presidential executive order 9066, which were followed by executive orders by the governors of the Western states. And what it did was it gave authority to remove all citizens of Japanese ancestry from the West Coast. And in California, about 200,000, almost all citizens, not all citizens, but almost all citizens of the United States were removed from the West Coast and removed into the interior in what we call internment camps. Not much of a difference between a prisoner of war camp and an internment camp. These camps had fences and gates around them, barbed wire around them, and guards to make sure that they wouldn't leave, and put them into rather squalid living conditions. The whole story is horrible. They were temporarily moved, for example, to some horse racing venues and forced to sleep in stalls that formerly had been used by horses. And anyone here know what a horse stall is like? I mean, people have to go in and muck the stalls because there's horse poop in them. And, some of the odors would permeate the wood in the stalls and stay there for long periods of time. And it was horrible. So in any event, Fred Korematsu was an American of Japanese ancestry who looked very Caucasian. His features made him look very Caucasian. And in fact, he was dating a Caucasian woman at the time. He was a young man, and he was working down at the Naval Yard helping to build ships that would eventually be used in World War II. He lived in the greater San Francisco area. And after these orders and everyone left, he decided to stay because he wanted to stay with his girlfriend and didn't want to leave California. He eventually was turned in. A lot of people believe that it was his girlfriend who turned him in. He was supposed to meet her at a certain location in downtown San Francisco on a certain day and time. She wasn't there. And instead, police officers showed up and escorted him to jail. The ACLU ended up taking his case. The case obviously went all the way up to the Supreme Court. And he said, I am being deprived of equal protection of the law because of my race and national origin. Probably as much as anything national origin, okay? Sounds like a pretty good case under strict scrutiny, because strict scrutiny applies to national origin. The government would have to come up with a compelling reason. As it turns out, there was no evidence that a single person on the West Coast of Japanese ancestry was a spy for Japan or working for the Japanese Empire or even sympathetic to the Japanese Empire. And that certainly is not the case with, was not the case with Fred Korematsu. He was as American as you and I. He was born here, and all his customs were American. So case went up to the Supreme Court, and the Supreme Court recognized, strict scrutiny. It should be noted to begin with that all legal restrictions which curtail the civil rights of a single racial group are immediately suspect. Courts must subject them to the most rigid scrutiny. So the majority opinion right here is saying this is going to be decided under strict scrutiny. And then for the rest of the opinion, the court went on and acted as if it were a rational basis test. It literally, the court literally accepted every representation, every vague representation of the government. The government said this is just too big a problem to deal with without removing the whole population. We can't risk disloyal, Americans who might be passing on information to the Japanese to help them with their invasion of the American mainland. We're at war, hardship's a part of war. He's not excluded on the basis of his race. He was excluded because Japan had invaded Pearl Harbor. And there was an impending invasion on California that was feared. Drastic times, drastic measures is what the court said. It turned out in hindsight, when a lot of these documents were declassified, that the government was lying to the court. And quite frankly, if the lawyers had been alive by the time this was discovered, probably would have been disbarred. The evidence seems to show that they knew that they were lying as well. One of the real problems in American history. Eventually, in the 1980s, during the Clinton administration, Fred Korematsu brought an action to get his conviction for violating this executive order overturned because he wanted to have a clean slate. And the court, in fact, actually did that. They eventually overturned the conviction. It would take more than 40 years for that to happen, unfortunately for him. Kind of a sad story. Loving versus Virginia. This is a very interesting case. There's been a movie made of this, which I haven't seen. I think the movie is called The Loving. The movie's called Loving. What's better than the movie, from what I understand, something I actually did see, is this really good documentary on this case, Loving versus Virginia, that was done by CBS News. Okay, it's done in black and white photography. CBS News got onto this case early on and followed everyone around with cameras. The lawyers who represented the Lovings and the Lovings themselves, they showed them at their home. And the reason for that was it became pretty obvious that this was going to become a big case. You've heard the word misogynation, I'm sure. Misogynation is discrimination against women. Back until 1967, when this case was decided, a majority of the states had miscegenation, not misogynation, miscegenation laws. Misogyny is when interracial couples get married, okay? And so misogyny laws ban interracial couples. Now, Virginia's was unique because it didn't say no man can marry no woman. This is the way it would have been phrased back in those times. No man can marry a woman if the two are of different races. What this one said, it was more specific, was that a black man or woman could not marry a black man or woman, okay? So it limited the misogyny to misogyny, to what the crafters of the law probably considered to be protection of the Caucasian race, okay? So very interesting story. Mildred Jeter was black, Richard Loving was white. They grew up in the same county in Virginia. At the time, it was a very unique county. It was totally desegregated. Blacks and whites lived together, treated each other as equals. And it was not uncommon for blacks and whites to date in this unique county in Virginia. Well, not only did Mildred and Richard date, they got married and they had kids. They lived in Virginia. Were not allowed to get married in Virginia because of the misogyny laws. So they went to Washington, D.C. to get married. And then they came back to live in Virginia. And literally in the middle of the night, authorities came in and arrested them and sent them to jail. And they went into court, and the judge said, I'm gonna free you on bail, but you're not allowed to live in this state anymore. If you want to stay married, you have to leave this state. They moved to Washington, D.C., but obviously both had family in the state and wanted to move back to where they were from. Mildred was the much more thoughtful, intelligent of the two. Richard was a bit of, you might look at him and call him, you know, sort of a redneck today. And he was a man of few words. He didn't do much of the speaking. She did. She was pretty articulate. And she wrote a letter to RFK, who was then the Attorney General. He, you know, said, go to the ACLU, tell them your story. So at this point, obviously, CBS heard about it and sent the crew out. And so I bet you can pick that documentary up online pretty easily on, or I bet you it's on Netflix or whatever. That one is called The Loving Story. The film that was made was called Loving, but the documentary was called The Loving Story, and it's very, very well done. I'd recommend it to you. So the ACLU represents them. They bring the case, and when they get to the courts, Virginia has a defense that it thinks is pretty solid. The defense is that there's no unequal treatment under the laws, because both of them got arrested here. Both the white man and the black woman got arrested. How can you say it's discrimination against on the basis of race when it applies to both the white man and the black woman? The Supreme Court did not really buy that argument all that well. And we're going to talk about this case again in fundamental rights after Thanksgiving, because one of the fundamental rights is the right to marry, obviously. And this case was decided on two grounds. One is the Equal Protection Clause, and the other is the fundamental right to marry. And the anti-miscegenation law was depriving the Lovings of the fundamental right to marry. We'll see that there's overlap between equal protection and fundamental rights. Very often when, even though you're going to use rational basis, for example, under equal protection, we'll see this in two cases. We'll talk about the Windsor case and the Obergefell case. Those were the same-sex marriage cases. In those cases, Windsor was technically a civil union case. When you see those cases, you're going to see that the Supreme Court on equal protection grounds decides them on the basis of rational basis. That's the standard that they use, because sexual orientation is still only rational basis. But at the same time, they're finding that there's a fundamental right to marry. What's the standard for fundamental rights? Strict scrutiny, okay? So they kind of get dragged along into strict scrutiny as well. Here, the Equal Protection Clause prohibits classifications drawn on any statute that constitutes arbitrary or invidious discrimination. The fact that Virginia bans only interracial marriages involving whites is proof that miscegenation exists for no purpose independent of those based on arbitrary and invidious racial discrimination. Here, like in Dred Scott, the law that gets shot down here, believes that the white race is superior and is trying to protect Caucasians from other racial groups, okay? There's a dominant race and a subservient race, and the white race is the dominant race, and it needs to be protected from, you know, quite frankly, in terms of genetics, it needs to be protected from dilution of the race. These are the same arguments that white supremacists use to this very day, is that the Caucasian race is being diluted through intermarriage and the like. Plessy versus Ferguson, a very, very famous case that is going to set up Brown versus the Board of Education, because in order to be decided, Brown versus the Board of Education has to overrule Plessy versus Ferguson. This was decided in 1896. Brown would come along some 57 years later in 1954, okay? Louisiana had segregation laws. And you guys have probably seen photos from the civil rights era in the 1960s, you know, where restaurants would have signs saying no colored people. That was the phrase that was used at the time. And then you'd actually see, I don't know if anyone has seen the famous photo of two water fountains beside each other. One says white fountain and the other says colored fountain. Teddy?
Another one where it's a laundromat, so it says it only washes white.
Only washes whites. Yeah, there you go. So that extended to rail transportation, you know, the primary form of transportation at the time. There was a separate railway car for blacks and a separate railway car for whites. Homer Plessy was an incredibly white-looking man, and that's because he was 7/8 Caucasian. He had 1/8 African-American blood. And at the time in the South, most of these segregation laws were based on the one drop law. If you have one drop of black blood, you're considered to be, for segregation purposes, you're considered to be black instead of white. Homer Plessy gets in the white car. Now look, people don't know about this, and there's an excellent book on this that I would recommend to you. I'm a film critic and a book critic today. There's a book called Separate. Separate is about the Plessy versus Ferguson case. And what I learned by reading this book is that this was a friendly lawsuit. It started out as a friendly lawsuit. The railroads didn't like having black cars and white cars. It forced them to hire more attendants, and it forced them to put more cars onto the railroad than they needed. The railroads actually wanted this law to be declared unconstitutional, as did obviously African Americans who lived in Louisiana. There was a large, especially in the New Orleans area, a large middle-class black population. In many ways, Louisiana was advanced in race relations. While there was segregation, blacks were allowed to get their sort of piece of the pie. Okay, and there were black doctors and black lawyers, and and the like. Homer Plessy was one of these middle-class people who was going to get arrested. He knew, unlike Rosa Parks, who just made an on-the-spot decision not to give up her seat to a white man on the bus, Homer Plessy went in looking to get arrested, and he knew he was going to be arrested because it was prearranged that he was going to be arrested. And think about it, no one would know that he was, under the label black, because he looked like a white man sitting in the white car, okay? So he's arrested. They don't tell you this in the case. Perhaps the Supreme Court didn't know this. I never knew it until I read the book. He was asked to move to the black car. He refused to, and he was arrested. And the case goes all the way up to the Supreme Court. You read this case, and the tone of it just kind of irks you as well, okay? Essentially, the tone is look, if the facilities are equal, then it is not a violation of the Equal Protection Clause under the 14th Amendment, okay? And the black car is just as nice as the white car. The 14th Amendment gives you the same political rights, but it's not meant to give you social equality. And it's natural for the races to remain separate. That's the whole thrust behind the rule. And you read parts of it, and the part that bugs you is, obviously, this isn't the problem. This isn't a white man's problem. It's a black man's problem. They want to be in the white man's car. That's their problem. Okay, so it kind of reads in a patronizing way. So here, this affirmed the separate but equal doctrine that would survive until 1954, Plessy versus Ferguson. You can segregate schools by race as long as the facilities are equal. Thurgood Marshall became a Supreme Court justice. Before becoming a Supreme Court justice, he worked for the Civil Defense Fund of the NCAA as an attorney who was going out and trying to shoot down these segregation laws. He was very successful. He's considered to be one of the greatest lawyers of the 20th century. Okay, he was very successful because he would go and he would prove that equal was not equal. The black school was not the equal of the white school, and it was pretty easy to show. You take some photographs and bring them into court and prove it. And so they were either forced to desegregate or forced to give equal facilities. And what did they do in the South? They would give equal facilities instead, rather than fully desegregating. Okay, so here, separate but equal is the law. Does not violate the 14th Amendment Equal Protection Clause if blacks and whites have equal facilities. So therefore, segregation continues in the South. Okay, very famous dissent, the Harlan dissent. It's kind of a moving dissent. It's well written. In view of the Constitution, in the eye of the law, there is in this country no superior dominant ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among its citizens. The very fact that they're separated here shows that there's a superior race and a dominant, superior race and an inferior race. And he's pointing this out. He even says the judgment of this, in my opinion, the judgment of this day rendered will in time prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case. Now, by that point, Dred Scott was considered to be the worst case ever decided in Supreme Court history. So that's a pretty strong statement on Harlan. He would not live to see the decision in Brown versus the Board of Education. Typo that I have there. Okay, now let's go on to Brown versus the Board of Education, 1954 case. What happened in 1954? A little bit of a backstory. This case was originally argued in 1953. Fred Vinson was the Chief Justice of the Supreme Court in 1953. He was a segregationalist. He believed in segregation of the races. The case was argued in 1953, and it was believed that Plessy versus Ferguson would be upheld by a 6-3 vote. There were 6 justices on the court who would continue Plessy versus Ferguson. The 3 justices who would have dissented, led mainly by Felix Frankfurter, argued that the case should be bound over to the next term and re-argued. Okay, and the justices were willing to do that. So they removed the case from the docket and put it on the docket beginning for the next term. The next term began in October of 1954. Prior to the October 1954 case being re-argued, prior to the term reopening, Fred Vinson died. In fact, Felix Frankfurter, who was a noted atheist, said, I forget what his quote was. It was a very witty quote, but it went something like this. For the first time in my life, I saw evidence that God actually does exist. And of course, he was referring to the death of Fred Vinson, who was the segregationalist. The new Chief Justice appointed was Earl Warren. Earl Warren was previously the governor of California. As a governor of California, he was very conservative. In fact, he issued the executive orders on the state level that assisted in removing the Japanese during the after the invasion of Pearl Harbor, removing them from the state of California. Okay, it was believed that he was going to become a know-nothing judge or do-nothing judge. He would just sort of go along and toe the line. He turned out to be just the opposite. He created the Warren Court, which would become the most judicially activist court probably in the history of the United States. Most of the civil rights and individual rights that the cases that you read about in criminal law, criminal procedure, and in civil rights matters came out of or were a direct result of the Warren Court. Okay. Some people think that the Warren Court went too far, was far too activist. We talked about our different viewpoints on the role of the judiciary. Okay, and so I think it's fair to say that, and it's not a criticism, it's a fact, that Chief Justice Rehnquist spent a good part of his time trying to undo what had occurred in the Warren Court because he considered it to be far too judicially active. Everything that the Warren Court did, he thinks could have been done by the legislature, and that's where it would have been better done. Okay, so Warren writes the opinion in this case. It becomes a unanimous opinion. 9 of the justices, quite a flip, isn't it? So you go from 6-3 in the opposite direction to all of a sudden 9-0. And here, essentially giving credence to the dissent in the Plessy decision, the very fact that you segregate people is done on the basis of a belief that one of the classes is superior and one of the classes is inferior. And the history of this country is that segregation is based on the belief that the white class is superior to the black class. And then what they did had never really been done in Supreme Courts before. The court had a bunch of footnotes, it was a fairly short opinion, believe it, except for the footnotes, used a lot of social science data to show the ill effects that segregation had on Black children in regard to self-esteem, and in regard to statistics involving upward mobility, social mobility, and the likes. And so they reversed Plessy versus Ferguson and said substantially equal is no longer enough. You can't have any segregation. Okay. In a subsequent case that came along, which we refer to as Brown 2, the question of a remedy came up. What are we going to do? We have all these segregated schools. We have all these segregated restaurants. We have all these segregated hotels. What are we going to do? And here the court dropped the ball. What the court said was, and this is the last sentence of Brown 2, the judgments below are reversed and the cases are remanded to the district court to take such proceedings and enter such orders and decrees consistent with this opinion as are necessary and proper to admit to public schools on a racially non-discriminatory basis. Here are the big words: with all deliberate speed, the parties to these cases. Okay. The words deliberate and speed don't necessarily go together. Deliberate seems to indicate carefulness and slow pace, whereas speed tends to indicate a fast pace. Okay. The result was, snail-like progress that was made after this. And unfortunately, most of the southern states would outright reject Brown versus the Board of Education. They would raise a new concept called nullification. Their argument was that we are separate sovereign states, and that Brown versus the Board of Education is an intrusion on our state sovereignty, so we have the right to nullify the decision. We have the right not to follow it. The Supreme Court came back in the Cooper case and cited, of all cases, Marbury versus Madison, and it said, no, the Constitution is the supreme law of the land, and we are the final arbiters of the Constitution, so we get to decide what the law is, and this is what the law is, do it. At one point, Dwight Eisenhower, the president, had to send in federal troops to get students admitted to public schools in Little Rock, Arkansas. Little Rock was one of the schools at issue in the Brown versus the Board of Education decision. Okay, look at the snail's pace progress. This comes right out of your book. In 1964, 10 years after Brown, 1.2% of Black school children were attending schools with white children. 1962, 1963, South Carolina, Alabama, and Mississippi, not one Black child attended a public school with a white child. 1961 in North Carolina, only 1/5 of 1%, 0.26% of Black students attended desegregated schools. In Virginia, 1964, 1.63% of Blacks were attending desegregated schools. What a lot of the southern states would do, what a lot of the school districts in the southern states would do is instead of desegregating, they would shut down the public school system. Obviously something favoring white kids, right? Because their parents could usually afford to send them to private school, whereas the Black kids' parents could not. So the courts had to force them to reopen the schools. Eventually, federal district courts started using busing to enforce the desegregation orders. And this went on largely through the 1970s, when the court essentially, made it an impossibility of working. So the idea is simple. And look, here's the primary problem that comes to desegregation of schools, okay? It's natural for people to want to live with people like themselves. So, for example, my grandfather came from Italy. He got off the boat in East Boston. You know where he ended up living? East Boston. I think he thought he had traveled far enough. Why did he stay in East Boston? That's where all the other Italians were, in East Boston, okay? And, people from the old country he knew before they all emigrated to the United States.
I thought there was the North End, no?
No, mostly East Boston. There's also no harbor at the North End that ships landed on. There were in East Boston. So the North End would eventually become largely Italian American. This is just natural. And so you get sections of the city of Boston where different ethnic groups and racial groups lived. Because of gentrification, this is largely eroding today. Now no one can afford to live in Boston anymore, apparently. Obviously Roxbury became a place where African Americans would congregate, parts of Dorchester. The Irish would go to Dorchester, to South Boston, to Charlestown, right? The other thing that caused this was that Boston, if I use Boston, and this is true in many cities, is a geographically separate city. even though it's a small city area-wise, it's not easy to get from one place to another in Boston. And so the result is that you had obviously a very segregated city. So the remedy that was adopted by most of the federal district courts was to bus some of the kids from their parts of the city to other parts of the city to attend other schools. And different school districts did it differently. You know, some just did it arbitrarily. So literally, you know, if I were a white person of Irish descent living in South Boston, I could be put on a bus in the morning and sent to a school in Charlestown. But I also might be sent to a school in Roxbury, okay? And a Black kid living in Roxbury could be bused over to South Boston. And longish bus rides, and creates another problem is that most people want their kids to go to school near where they live, okay? It's easy in the suburbs. I walked to elementary school, I walked to middle school, and I walked to high school. You know, small enough town where you could do that. You know, I didn't really grow up taking a bus all that often. So, so the idea was, oh, and one of the other problems the parents hated was a brother might end up being sent from Roxbury to South Boston, whereas his younger sister, who grew up in the same household, doesn't go to South Boston, might go instead to Charlestown. So you got different kids going in different directions at the same time. And you know, there were a lot of protests, a lot of problems with it in the late 1960s and early 1970s. Boston, in particular, had an awful lot of civil unrest as a result of busing. But at the end of the day, you know, how else do you desegregate the schools? This is what the judges in the federal district courts were thinking. So, Swan versus Charlotte Mecklenburg, 1971 case, gives the judges the go-ahead to use busing. Once a right and a violation have been shown, the scope of the district court's equitable powers to remedy past wrongs is broad, for breadth and flexibility are inherent in equitable remedies. In seeking to define, even in broad and general terms, how far this remedial power extends, it is important to remember that judicial powers may be exercised only on a basis of a constitutional violation. Remedial judicial authority does not put judges automatically in the shoes of school authorities whose powers are plenary. Judicial authority enters only when local school authority defaults, okay? What would be the undoing of busing as a means of racial desegregation? It would be the fact that at the end of the day, the students came home to their Black neighborhoods or white neighborhoods. And so while you were desegregating the schools, you were not desegregating the neighborhoods. And so segregation remained a large part of life. In Milliken versus Bradley, a judge decided to get creative and to sort of end this problem. Detroit had a long history of segregation by race. By the time the case reaches the federal courts, Detroit has a huge Black population and a tiny, tiny, tiny white population. One of the things that busing did was it created a phenomenon called white flight. So if you were white and could afford to move out of the city, you would move into some of the suburbs. Anyone of Irish descent familiar with the Irish Riviera? So the South Coast, south of Boston, is the Irish Riviera. Milton, Canton, pretty much all the way down to Scituate have large Irish populations because they could afford to move out of the city and did so. Okay, so this had happened in Detroit, this white flight. By the way, the other thing that happened in a lot of cities is that families who could afford to would choose parochial education. So they'd take their kids out of the public schools because they didn't want them bused, and put them into local parochial schools. So if you're from Dorchester, what do you say? What do you say when you meet someone who's from Dorchester? What parish do you live in? Right? I mean, literally, what parish? They, you know, so many of my friends from Dorchester went to parochial schools when they were kids, all the way through. So judge sees the problem. He says, look, if I issue a desegregation order and I issue busing orders in Detroit, what's going to happen? A black kid from a black neighborhood will be bused to a school that's already black. And the kid who's being bused from that neighborhood would be sent to another school that's already a black school, okay? And so you're not desegregating at all. You're just moving people around, and it's not achieving anything. So what does he do? He creates this unified school district with 54 former different school districts all put into one. He says the only way Detroit is going to become desegregated is to use something other than an intra-city busing system. We're going to have to use an intercity busing system. And so he puts all of the suburbs into the one school district. And so inner city kids are going to go to school out in the suburbs, and suburban kids are going to go to school in the city. You know, and I'm not saying that all suburban kids will go to school in the city. I'm not saying that all city kids will be going to school in the suburbs. But there's a system where there's going to be true desegregation going on here. This is great until the Supreme Court says you can't do this in 1974. 5-4 decision. The Supreme Court says you're taking communities that did not have a history of segregating their schools to put blacks in only one, to put blacks in one school and whites in another school. You're punishing those schools for the problem that exists in the cities. Okay. So what this case stands for is the proposition is that you can't order these remedies unless there's a history of discrimination that led to segregation, number one. And number two, you can't force other school systems to participate that don't have a history of discrimination. Now, why don't the suburbs have a history of discrimination? They're all white. They essentially had segregated schools because everyone was white in the schools, and they weren't excluding black children from the schools because there were no black children coming to the schools. And you know, the result of this, and I'm not necessarily criticizing the decision, you know, this could have put kids on a bus for an hour and a half each way, right? And so there are certainly flaws with any busing scheme, but this essentially meant that there was going to be no desegregation of the schools. And as we talk here today, you know, inner city schools are just as segregated as they were at the time of Brown versus the Board of Education, largely because of the white flight phenomenon. And oddly enough, the only thing that could be changing this all is the gentrification of cities. You know, up until the COVID, there was a big move of people coming back into the city. Everyone wanted to live back in the city. The result of which was that, you know, even areas of the city that were considered to be socially lower class, economically lower class, are becoming gentrified, and the houses are all being redone, and literally no one can afford to live in Boston anymore. If you don't have $1 million, you can't really live in Boston, unless you inherited your house, so to speak. So there we go. You know, that's the whole story of segregation. Some of the other cases will tell you that the other thing the courts had been doing is for school districts that have largely been following court orders to desegregate, they started dissolving the injunctions in regard to those schools. Busing stopped and the like, and then there was a history of segregation coming back to some degree there as well. So, you know, Brown versus Board of Education was an awesome case, you know, when it came to enforcing the 14th Amendment. Unfortunately, the court did not come up with an awesome remedy that would help with desegregation. Okay. this is what this is the point where I'm going to tell you how I'm going to screw you. Okay. Are you ready for this? Okay. Some laws are discriminatory on their faces. Obviously, segregation laws are facially discriminatory. You know, what did they say? No black child will go to a school with white children. No white child will go to a school with black children. That's easy. You know, voting suppression laws used to be very facially discriminatory. Okay. Governments got better at that. And there's this phenomenon that occurs where a law might not even be meant to discriminate on the basis of race. It might be meant for a laudable purpose. But when it's applied, the effect of the law is that it discriminates. Okay. So some examples, a couple of these are pulled from your book. A couple of them are my own. You know, when the federal government did the war on drugs, they put very harsh penalties on the possession of some drugs. And they distinguish between crack cocaine and powder cocaine. And there was a much harsher penalty for crack cocaine. Okay. So unfortunately, because crack cocaine is cheaper than regular cocaine, in the 1970s and 1980s, cocaine became the drug of affluent white folks, whereas crack cocaine became the drug of less affluent people, many of whom were persons of color. So therefore, we both use cocaine, but I get a longer sentence because my cocaine happens to be crack cocaine. The odds are that I'm going to be a black man instead of a white man who's getting the harsher sentence. Okay. So again, you look at the law itself, and there's nothing on the face of the law that said it's meant to discriminate against persons of color. But what's the effect of the law? It discriminates against persons of color, obviously. Okay. Same thing happened with the draft in Vietnam. The draft was reinstituted in Vietnam. Literally, they would put your birthday into on a little piece of paper, put it into a capsule, put the capsule in a big bin, spin the bin, and then draw out the numbers. And if your birthday came up in the top 100 of the numbers, it was one of the first 100 chosen, odds are you were going to Vietnam. That's what was supposed to be the case. One of the reasons why they did the draft was because who always fights the wars? Rich man's wars fought by the poor man, right? Okay. And so the idea was to actually try to equalize who would be sent to Vietnam. You couldn't get out because of your social status, so to speak. I mean, literally in the Civil War, people would actually pay other people to go serve for them when they were drafted. And so people of privilege were avoiding having to fight in the Civil War. So the idea is to prevent racial discrimination. But what happens? At the time, about 10% of Americans were of African American descent. Okay. Today it's about 13, by the way. But back in the 60s and 70s, it was about 10%. Yet, what was the percentage of troops actually serving in Vietnam who were black? Close to 50%. So this is obviously a disproportionate representation as to who was actually sent. Why did this end up being the case? Well, the law is not purposefully discriminatory, but people who can afford to have a doctor write a letter saying that they had a disability that should be preventing them from attending the war did. Okay. And most of our recent presidents didn't have to serve in Vietnam, you know, for similar reasons. Okay. The current president included, Bill Clinton included, George W. Bush. What George W. Bush did was he went into the reserves. Back in Vietnam, if you went into the reserves and committed to 5 years in the reserves, you would not see live action in Vietnam. They changed all that because of Vietnam. If you were in the reserves during the First and Second Gulf War, you would then be put on active duty and sent to Afghanistan. or to Iraq, essentially. Another racially neutral system we have, and the one we're going to talk about with this first case of Washington versus Davis, are standardized tests. Now, standardized tests have a legitimate purpose, a legitimate goal. When you have so many different school systems across the country, an A from one school system doesn't necessarily mean the same as an A from another school system. So when kids apply to go to college, someone has a 4.0 average from a school system where everyone gets a 4.0. That doesn't mean as much as someone who went to a very rigorous school where in order to get a 4.0, you'd have to be at the very, very top of your class. And so these standardized tests, the SAT, the LSAT, were created to sort of make sure that, make sure that the criteria that they were judging had some commonality to them. So what's the result? The result is simple. Even though, the requirement of the SAT and the LSAT is not for discriminatory purposes and does not facially look like it's for discriminatory purposes, what happens on those tests? People from lower socioeconomic backgrounds score much lower on those tests than people who are wealthy. If you see the statistics, it's almost a perfect ladder where the rungs are exactly, the same distance apart. Wealthy kids tend to do well on the SAT, the LSAT. Poor kids don't. And there's a greater likelihood that someone who's poor is a racial minority than someone who's wealthy is a racial minority. So what happens when a law does not facially discriminate, but has a discriminatory impact? The effect of the law discriminates. That's what happened in Washington versus Davis. They have their version of the civil service test is test 21. The purpose for it was laudable. Obviously, police officers are required to communicate with members of the public. Therefore, we want people with good communications skills and people who have good critical judgment skills. So we're going to create this standardized test, test 21, a written verbal exam. And no facial classifications based on race, but African-American test takers do far lower on the scores than Caucasian test takers. The result is that in Washington, D.C., a city with a large, Black population, you have a very small police force of color. Very few of the members of the police force were persons of color. So this is challenged. And here's what the Supreme Court says. You think this is important? Have I given you enough exclamation marks here? Okay, this is going to be on the test. Let's see who's up for it. An official action will not be held unconstitutional solely because it results in a racially disproportionate impact. Unless the plaintiff can prove the government acted with a discriminatory motive, facially neutral regulations, such as those occurring in Washington v. Davis, will be reviewed under rational basis scrutiny rather than strict scrutiny. So if there is no facial racial discrimination, the test will be rational basis, unless the plaintiff can prove that the reason for the law was racially motivated. The law was meant to discriminate, okay? So you've got to show motivation or intent, all right? You got to find the smoking gun. Is the smoking gun always findable? It's rarely findable, okay? And it requires a lot of work to go out and find it. Similar case, McCluskey versus Kemp. A Black man who killed a white man was given the death penalty. He cites a study showing that Blacks are 4 1/3 times more likely to receive the death penalty than whites. The death penalty laws say nothing about race. They're facially neutral, but the effect of them is that far more persons of color are put to death in states that have the death penalty than are white people. And the court says the same thing. Washington v. Davis, this is not a facially neutral, I'm sorry, this is not a facially discriminatory law that you're challenging here. You've got to show discriminatory motive. You've got to show that they wanted to discriminate in creating this death penalty. Unless you can show that, you're not going to lose. You're not going to win. You're going to lose. Okay. All right. There are a lot of affirmative action cases. I'm going to give you a short primer on affirmative action. And we're going to end the class here for today. I thought I would get a lot farther, but obviously I didn't. We'll save gender for, so gender will be in class 25 and the rest of equal protection will be in class 25, which again will be posted and you can watch on your own timetable, okay? It's important stuff. I'm not telling you not to watch it, please. I'm telling you have to watch it, okay? It'll be quizzed as well. So, you know, you're gonna want to look at it, okay? And then we'll get into fundamental rights in class 25 and finish those up through the end of the semester. So back to affirmative action. Affirmative action occurs when education is an easy place to examine this from. When a college ends up using race as an affirmative factor for admission. The college wants to have a diverse student body. And studies have shown that diverse student bodies enhance learning for both white kids in colleges, they're not kids, white students and black students, okay? A lot of colleges started doing affirmative action plans where you would get a little boost, some type of a boost if you were a member of a racial minority. You would get a boost if you were a woman, okay? A lot of fields to this day are known as, gender fields, right? So engineering tends to be occupied mostly by men. Nursing tends to be occupied mostly by women. Obviously, diversity in these fields is good. So the first case that the Supreme Court decided was the Bakke versus Board of Regents of the University of California. Alan Bakke applied to medical school at UC Davis. There were only 100 seats open at the time. What UC Davis did was it gave, I wish I could remember the number, but it set aside a certain number of cases for persons who were economically and culturally disadvantaged. Essentially for persons of color. So Bakke didn't get in. He sued, claiming discrimination on the basis of his race. He was white, because people with lesser credentials got in and he didn't, okay? The Supreme Court, it was argued by some of the justices in this case that we shouldn't use strict scrutiny when it is a so-called benign classification. In other words, we are trying to create opportunity for those who have been discriminated against in the past. And so to the extent that we're discriminating against Caucasians, it is a benign racial classification, and therefore we should use intermediate scrutiny instead of strict scrutiny, okay? The court rejected this. The court said the equal protection bars discrimination on the basis of race, whichever race is discriminated against. So whether it's the persons of color who are discriminated against or Caucasians who are discriminated against, we have to use strict scrutiny, okay? Now the court then came up with a number of compelling state actions in Bakke. And what it said was diversity in education is a compelling interest. that would in fact justify an affirmative action plan, okay? However, it said two problems. In this case, there is a strict racial quota. A certain number of seats are set aside for one race. That can't be done. So Bakke ended up getting in, okay? He sort of lost the cause, but he sort of lost the war, but won the battle, okay? The court said race can be a factor, but it has to be a minor factor, to not be an overly important one. And this was reconfirmed in Grutter versus Bollinger in 2003. And then surprisingly, in 2016, in Fisher versus University of Texas. For that case, all of us who taught con law thought that that affirmative action was out. We thought that the Supreme Court, they were heading in the direction of overturning, Bakke and Grutter versus Bollinger. One of the things that Justice O'Connor said in Grutter versus Bollinger was that at some point, affirmative action has to end. You just can't have it forever, okay? And everyone thought that the court was going to say in Fisher versus University of Texas, 13 years after Grutter versus Bollinger, we've reached that point, but they didn't. They kept it alive, okay? But here's the big deal with affirmative action. It is acceptable. First of all, you're not going to see it in private colleges cases, are you? Because it's state action doctrine, okay? So Grutter versus Bollinger was the University of Michigan. Bakke was the University of California. Fisher was obviously the University of Texas. The facts in Fisher are a little bit more complex than we're seeing here. So two things. One, no strict racial qualifications. Three things really. Two, race can be considered, but has to be sort of an add-on, a minor add-on. It should not be alone determinative of whether you get in over somebody else, okay? And then finally, Grutter tells us this is a temporary solution to the racial problem in the country. At some point, it's going to end. I doubt it's going to end before you guys take the bar exam, but it will end at some point, okay? All right, on to exam week for you guys. Good luck. I'll be running some office hours next week. I'll send you out an email on that. I'll probably do more of them than I do instead of the Wednesdays at 11 and 6. I'll be doing them at I don't know, on several days for people who have questions. If you have any questions and you want to email me, by all means do that. If you have a whole bunch of them at once and they require long answers, don't expect their email return on the same day or within a matter of moments. Okay, but I will.
Do we have a
answer
quiz this
emails.
weekend, Professor?
Yeah, you'll have a quiz. Quiz
thank
posted
you.
tomorrow.
Are we
Yeah,
getting a week
It'll
off?
be
We're not
due on
getting,
Monday.
are we getting a quiz the week off we have, like those 2 days to study for exams?
So tomorrow, I think will be quiz 11. What I'll probably do is in the last week, I'll give you, after Thanksgiving, I'll give you quiz 12. And that's probably going to be it. Okay.
So we'll have one
Um,
next week though. That's the question. We have an exam next week as well? I mean, a quiz, I'm sorry, a quiz next week as well?
no, I just said no. The quiz tomorrow is going to be quiz 11.
Oh, I'm
You
sorry.
won't get another quiz until after Thanksgiving.
Gotcha, thank you.
Okay, you bet.
Harvard just had a case too on with Asians, with discrimination, but anyways.
Yeah, that was a very different case. It involved discrimination under sort of federal funding laws and the like. It was a bench trial.
Gotcha.
We can talk about that a little bit when we come back.
Thank you, bye-bye.
Okay, bye guys.
Thank you. Bye.
Thank you. Now if I can just get out of here.